Welcome to this YouTube channel of K Leaders. I'm Francis Chan.
I'm Carmen Chi.
Hi Carmen, last episode we talked about Shareholder Agreement. And this episode we are talking more details about this agreement.
Yeah, so in this episode, we're going to cover the usual provisions you would normally see in a shareholder's agreement. Yeah, so Francis, last time we talked about control being really important for a founder.
Yes.
So one of the ways that you can exercise control is to put certain favorable provisions into the shareholders agreement.
Yes.
So now let us take a look at this.
Okay.
So one of the ways to exercise control in a company is for the shareholder to be, maybe nominate the majority of the board. So it is quite often that you will see the board composition provision in a shareholders agreement. Now, usually what would that include is that shareholders are able to nominate a certain number of directors in the company. So let's say if you have 3 shareholders, with one shareholder being the major shareholder, with the other 2 being the minority shareholder. And then a lot of times, like maybe they would set in the shareholders agreement that, for the board, there will be a minimum or just a maximum number of directors being, let's say, 5 directors. And the major shareholder is able to nominate 3 directors, and the other 2 minority shareholder are able to nominate just 1 director each. So this way, the major shareholder is able to exercise control at the board level. And also the quorum. A lot of times you will see major shareholder would want to ensure that directors nominated by them would actually be required to attend directors meeting in order to form a quorum. Or they would want to exercise control that, if they were to pass certain resolutions, then the affirmative vote of a particular director that's nominated by let's say the majority shareholder is required. Another thing is, and I usually suggest it to my clients, is that they should prepare 2 lists of important commercial decisions. Now, one list is for the board and the other list is actually for shareholders. These 2 lists, they would basically include important commercial decisions for the company that would require the approval board level, or if the decision is of a significant value, then they wouldn't just require approval at the board level, they would also require approval at the shareholders level.
Yes.
Well, let's say, just as an example, maybe the board is able to approve contracts of, let's say, a $1 million consideration contract. But let's say if the commercial contract is of a higher value, let's say like $5 million US, then they would require the shareholders' approval. So these 2 lists, they're usually attached and form part of the shareholders' agreement.
Yes, we see that in our client case.
Okay.
If the business grows and needs more capital, I think they will call the shareholders to inject capital by allotment new shares. So in those circumstances, what would you suggest?
Let's say if the company does issue new shares, so what would it mean for you as a shareholder? So it would mean, let's say if you don't subscribe for additional shares, okay, it would just mean that your shareholding in the company doesn't remain the same, but in fact, it will decrease. So a lot of times you will see anti-dilution provisions and also preemptive rights provisions in the shareholders agreement.
Yes.
So for anti-dilution provision, you will normally see that, in the event that the company issues, new share, they would actually issue additional shares to the existing shareholders so that they're able to maintain their existing shareholdings. And then as for preemptive rights, this would actually give the existing shareholders a right to first subscribe for additional new shares before the company issues these new shares to a third party.
Yes, I think this is very important. Huh?
Yeah, of course.
Yeah. So if one of the shareholder want to reduce its shareholding in the company or even exit,
Right.
then what would you suggest?
Well, normally you would see transfer of shares provisions in shareholders agreement. If let's say a minority shareholder, let's say someone who holds like a 20% shareholding in the company wants to just exit. Well, when they want to exit, they will actually need someone else to buy their shares, right?
Yes.
Which in effect, what does it mean for you as a remaining shareholder? It means that you're going to get a new business partner, right? And this new business partner may or may not be someone that you actually want to partner with,
Sure.
right?
Yes. Correct.
So you would actually want to make sure that you have provisions in the shareholders agreement whereby, you're basically given a right to first purchase the shares of the minority shareholder or the shareholder that will be exiting. So
Yes.
this way, you're actually able to control who would actually come in and be your business partner. It may be the case that you actually don't want someone new to come into your business, and you may just purchase and buy out the minority shareholders' shares so that nobody new comes in.
Yes. Yes. To me, if I don't want somebody to be the partner or the shareholder, then definitely it's a cost that must be included.
Yes.
Now, if my business grows,
Yeah.
then someone knock at my door, Francis, I want to buy your business, but I'm just a 90% shareholder. Then
Right.
10% is owned by somebody else. Then what should I do then?
Well, in that case, I'm sure you heard of drag along and tag along provisions in shareholders agreement, and it's actually quite common, especially if in your partnering relationship you have major shareholders and also minority shareholders. A lot of time, the major shareholder would actually want a right to be able to drag and make the other minority shareholder to follow them and sell the shares. Like if, let's say, like a professional investor comes in, wants to buy your share, and they actually they want to buy the entire company. So a lot of times, like the majority shareholder would actually want to include that provision in the shareholders agreement.
Yes. Now, what if my business is very good in performance? Then my partner or staff to go out and do similar businesses.
You mean setting up a competing business while they're in business with you?
Yeah.
Oh, okay. Well, it's not unusual, and in most of the cases, you will see non-compete provisions in shareholders' agreements. So you want to make sure that your business partners don't go out and set up a competing business to compete with the business that you guys are in right now.
Right.
But there are a lot of times that maybe some of your investors are actually professional investors, and of course, as a professional investors, they do invest in other business, and it may very well be a competing business as well. So sometimes like these non-compete provisions, they do need to be tailored to cater for such a situation where they will carve out certain industries or certain business to be not competing business. Just so that this is just to prevent one of the shareholders breaching this non-compete business. And a lot of times, like this is something that a professional investor would actually require.
Yeah, I think it is important that the competition clause is well drafted. Otherwise, no one will be willing to partner with me because after doing business with me, then they cannot do similar business sometime in the future.
Yeah.
Common, I have a kind case because the majority shareholder can nominate a director to represent them in the board. And that particular director have the influential power that without his presence, no resolution can be passed.
Right.
But that director never appear in any directors meeting. So no board meeting can be convened and no resolutions can be passed. So in those circumstances, what should be done?
In a shareholders agreement, you're going to see dispute resolution provisions and also deadlock provisions. So these provisions are basically catered for, the situation that you just described. So in the event that business cannot be passed at the board level because somebody is not cooperating, then what would happen? So a lot of times, deadlock would actually be basically reflected up to the shareholders to be decided at the shareholders level. So normally you might see, well, one of the ways to push things forward is for maybe the two major shareholders to meet together, just as an example. They would meet together and they would talk things out and try to resolve the matter and hopefully be able to move things forward. But there will be circumstances where the shareholders are unable to resolve their differences. So in that case, what would happen? And a lot of times there will be provisions that sets out, well, if the shareholders can't agree on disagreements, then maybe one shareholder would buy out the other, so that while one shareholder is able to continue with the business just without the business partner.
Because I have another kind case
Right.
who the majority shareholder must be a quorum, must be
Right.
present in order to form a quorum. But similar, no present. So no shareholders resolution can be passed. So it becomes a really deadlock because no director meeting, no shareholders meeting.
Right. Okay. So
So-
the business relationship has basically just failed.
Yeah, so the business cannot continue without those meetings, those resolutions.
Ah.
So I think is it the only option maybe just to apply to the court or to do some arbitration beforehand?
Well, I think this may be something that we can cover in our next episode, because next time we're going to be talking about, well, passing of a resolution. So maybe this is
Good.
something that we can talk about.
Good.
Yeah.
Yes.
Well, one thing I want to bring to everyone's attention is liquidation preference. I think last time I've mentioned that for professional investors, they would normally require liquidation preference provisions. So this is something that you will also see in a shareholders agreement, whereby, well, maybe a few professional investors, they would want to get their money back, like in the event the company liquidates. But in terms of priority, then who would get their money first? I mean, this is really, it really depends on the commercial position of each individual investor. Now, once you've done your shareholders agreement, is it necessary to amend your company's articles of association in order for it to be in line with the shareholders agreement?
Is it required?
Well, the short answer is yes, but you don't have to amend every single provision in your articles of association. You will only be amending some provisions, but which provision to amend, it really depends on what has been agreed in between you and the other shareholders. So I'll let Francis talk about amendment of articles of association.
Thank you, Calvin. Yeah, I think just to draw your attention that the shareholders agreement is a private agreement. So no need to file it with the company registry. But the article of association is a public document once it is filed with the company registry. So once the articles is amended, you need to reprint the whole articles and submit it together with the special resolutions with a specified form to the company registry within 15 days. So this is so important. But I think as Carmen mentioned, that not every single provisions in the shareholders agreement will be included in the articles, because as I said, articles is a public document. Once you record the cost, the requirement in the articles, it become publicly available. So I don't think you would like to disclose every of your contractual terms in the articles. So the articles may only reveal those very important clauses like how to form a quorum for meetings, how to pass resolution, this kind of things. So be careful about this.
Yes, I agree that the shareholders agreement is a commercial agreement, and there's really no need to set out all your commercial provisions in the articles of association. But there is one thing. So how long would it take you to amend the articles of association?
Carmen, it depends on how much you would like to amend. If you are just a little amendment, I will do it very quickly.
See, so that's why lawyer and company secretaries, we all need to work together in order to get the Articles of Association amended and to get your shareholders agreement done.
Yeah, because company secretary is not a lawyer, and client also may not have the legal background. So if the shareholders agreement is so important to you, then I think it is suggested to have contribution input from the lawyers before you finalize the agreement.
Agree.
So thank you so much for watching. Carmen, what will we share next time?
Well, I think next time, given that we've talked about shareholders agreement this time, I think next time we talk about implementing the shareholders agreement and what it really means when you have other shareholders. So we're going to talk about how to pass resolutions at board level and at shareholders level.
Okay, thank you so much, Carmen. Thank you for watching. See you next time.
Thank you.
Bye-bye.
Bye.
Thank you for watching this video. If you like it, please give us a like and subscribe and share with your friends. Look forward to your continued support. See you next time. Bye-bye.